Hi, can you please guide on inheritance of property if parent is terminally sick? So if the parent is sick, the best scenario for purposes of estate planning is if the ill parent has a will. If he has or he or she has a will, in that will, that's the best instrument by which the ailing parent, can provide for how he or she wants to dispose of the estate and the properties in particular after their passing. So if you have a will like that, that is perhaps the most efficient, the most sure instrument by which the family can have some comfort and confidence in terms of how the assets will be distributed and that they will be distributed efficiently and effectively. Now, in terms of the will, it depends. The best thing to do is to have a local will. And by local, I mean the UAE will, especially if it covers properties in the UAE. These days, it is more possible, perhaps a little more acceptable, to have enforcement of foreign wills, but it does involve a court process, so it's not as streamlined as having a local will. Now, if the parent is still alive, the good thing is that they can still do a will while they are, although they're sick. There are no restrictions to that. Now, with regards to what type of a will, it much depends on whether it's a Muslim family or not a Muslim family, because for Muslims there's a more limited chances or choices of registering the will. But there is an option through ADJD, which is Abu Dhabi Judicial Department. And we have actually had very similar cases of ailing clients who have since passed that were able to do a will through ADJD, and the family was then able to benefit from a very clear mandate of estate distribution after the passing. So the best thing is to seize the moment and have a will. Depending on what the religion of the parent, you will either have options of ADJD if the parent is Muslim. If not, then you have ADJD and the DIFC and other types of notaries that will provide for a will in such cases. So that's the best option. The second option is while the parent is still alive, obviously they can give a power of attorney, and you can do certain things on the basis of the power of attorney, in particular property transfers, for example, but you can only do it while the parent is still alive, because once the person dies, the power of attorney effectively dies with him or her. So this is very important to keep in mind, that you're not legally allowed to use the power of attorney or rely on the power of attorney after the person's passing. And so the third option, if none of this is possible for one reason or another, it's not possible to do a will, and it's not possible to act on the power of attorney for one reason or another, then it will ultimately be up to the court to deal with the distribution of the estate as per the relevant laws that would apply in the case of your parent. Now, what the relevant laws will be depends on whether the family is Muslim, what nationality, and then so on and so forth. So it's a simpler process today than it was in the past, but ultimately the court will be in many ways applying the principles of Sharia, figuring out who the heirs are as per Sharia. So it's not the ideal, perhaps, scenario for those who are not Muslim, because sort of it's a different process that applies. But that would be kind of the last option. Certainly, there's plenty of cases that have been adjudicated, and it's a lot more transparent these days of what you can expect. But that perhaps, if there's a choice, this should be sort of a measure of last resort, and the other two choices of having a will and or POA should be first.